Hello, everybody. My name is Geoff Wild. I'm the founder and former editor of IAM, now in semi-retirement, and I've been lured out of that semi-retirement to moderate this webinar, which is looking at two of the probably hottest topics in IP currently, that is AI and SEPs, and how they might work together in the future. We've got a fantastic panel for you this afternoon. Conrad Voits, the Chief IP Officer of KPN, Julian Nolan, the founder and CEO of Iprova, Harry Cronin, also from Iprova, where he is the lead innovation engineer, and Tim Coleman, the founder and CEO of IPlytics. Before we get underway, I just have a few very quick housekeeping points for you. First of all, this is a session that's scheduled to last for 60 minutes. It will be recorded, and the recording will be made available after the session has finished, as will the slides that will be presented during the session. If you want to ask a question, please do not use the chat facility, use the Q&A facility. You're welcome to submit questions at any time during the session, but we will not be looking at responding to them until the end, if there is time. Obviously, if you have specific questions about any of the issues raised, you're free to contact individual participants afterwards as well. With that housekeeping, and bearing in mind the brief time that we had, I'm going to hand over first to Kern from KPN to talk us through his first set of slides. Kern.
Thanks a lot, Geoff. And let's wait a second for the slide. So I've tried to translate the Dutch saying, which is a famous one in the Netherlands, in the little English there. But as everybody in the profession, I think we have all our dreams, and there is also a certain reality. So today we are to speak especially about standard essential patents. If we go to the next slides, I'll try to introduce the issue of standard essential patents and how it keeps us, people in the companies, out of sleep, while the lawyers all around the world make a lot of money on the standard essential patents, and some companies too. So in three catchwords, that's how I bring it to my management. There are thousands of these standard essential patents around, and they can stop our business in a matter of months, which is no longer so, these 3 months, but the time scale has become like 12 or 18 months all over the world. But the torpedo option is there. The business injunction option is still there. It's responsible for a lot of our purchase spending, and some companies make good profit on the standard essential patents, some others not. If we go to the next slide, let's go to the friend scene. Now it's the second time, or the first time we use the word friend without explaining. So in the next slide we will. So where does the issue of standard essential patents come from? We have to understand that in the ICT industry, especially telecommunication, you cannot work without communication. You cannot have anything proprietary. So you have to agree among the participants how you interact, which protocols you use to understand one another. So we have interacting systems, and not only that's a problem in the telecommunication industry. People keep on a tremendous pace, keep on developing new technologies, which then have to work with one another. Like today, we try to find solutions to the 5G network or the LTE network takeover when the cable network fails, and vice versa. Long story short, we have to find out these solutions by standardization, where the whole industry is coming together and trying to find a technical optimum solution, which means all actors are there, like 50, 100 companies, which means that the final result is an amalgamate of on the input of hundreds of different companies, which means that you are floating on a sea of thousands of patents owned by 50 to 100 companies, which is something where the patent system was not meant for. So we have a clash of patents, clash of intellectual property rights, and the patent system was not meant for that. On top of that, quite some companies have discovered the idea that if it's there, this problem, let's try to make a licensing revenue from that and have like our second revenue stream. If you go to the next slide, I'll bring it a bit more to try to explain a bit better what it's all about. So we spoke about the standards, that the standards are made by the voluntary contributions of different companies, and that all of these patents, IPRs of different companies are all together in one standard. Now, everybody has to follow the standard, and that while the people that have then the patent can play like a cat and mouse game with the implementers, because you have to follow, but they have patents, so can injunct you. So that doesn't work. So the antitrust authority has quickly entered the scene already in the 90s, early 90s, and has made clear that on these patents, in principle, one cannot have the injunction power anymore, but we are allowed as patent owners to license our patents on fair, reasonable, and non-discriminatory terms and conditions. So that's the friend paradigm around SEPs. There is another element in the game, that is that while we are in the standardization community, we should timely make clear that we have patents on a certain solution that is worked out. And that's for that reason we have to make these standard essentiality declarations, and we should do that timely as well. All of this, of course, is to avoid that the industry is coming into a lock-in. Now, those of you who are aware about the situation in the standard essential patent field, when they heard me saying injunction is no longer possible, I think half of the audience exploded, went to the ceiling. I did say, in principle, the injunction is not possible, but there is a lot of what if about it. But that's not what the seminar is about. I just introduced the idea of standard essential patents and the friend commitment, and the point that we have to make declarations, if possible, if we are aware about the essential nature of our patents while the standard is made. We can go to the next slide. Because I don't know my slides by heart, so if you can go to the next slide, the one who is organizing the slides.
I see the next slide.
Yeah, thanks a lot. Yeah. So what I spoke about has resulted in what we can call the tragedy of the uncommons, that all the companies that are entitled to request or ask for licenses on their standard essential patents, they do that, and then you come in a situation that company one is asking a friend license, company two is asking a friend license, company three is asking that, but in the aggregate, the question is all of that still friend? Then you have all kinds of other problems around, which I've summarized in the slide. And we have observed that while at the beginning days of the 2G technology, the total royalty burden in the industry was relatively low, bearable. At that time, of course, the margins were even higher. As much as technology evolved to 5G today, the total aggregate royalty burden has become very, very high, like double-digit percentages of the net sales price of products. So the question really arises, is profitable business still feasible? We don't have to worry about that in the seminar. It's just the issue which you should be aware about when you hear the presentations. And we can go to the next slide then. So, and this is based on public declarations of companies at the time that LTE 4G was launched. That's already a man age ago. Well, I speak about 2010, about to be precise. A number of companies have declared how much royalties they would request as what in their opinion would be a friend royalty level. And if you add all that just for 10 companies, which are listed here, you end already up with a double-digit royalty level. And that's not all of the companies. If you can go to the next slide. So this is like a summary. We have quite some issues to cope with in the telecommunication industry with the standard essential patents, while the industry is under margin pressure, like most industries all around the world. What we have seen, though, in the early 2010, so 2010 to 2015, is that the high royalty demands from a number of companies by litigation and by decisions of the judges have been mitigated down quite to a much lower level than what the patent owners had dreamed about or would dream about. And that has led to the situation that over the last 5 years or the last 10 years, seen that the implementers see that the judges are sympathetic for the problem of this aggregate royalty burden, that many implementers do not wish to take a license anymore unless one is going to court, or even unless there's a court decision. We can go to the next slide. So what are the challenges that we are facing then in the telecommunication industry? What has the standard essential patent issue created? What has the friend commitment created? And that's all basically about costs, of course. We have to invest in research and development, like all companies. Research and development results in patents, and this is a common theme in all industries. Not all of the 100 patents that one files will lead to patents in use, even not in your own company. If one comes to a ratio of 1:10, I think that's the industry average. If one can come to a ratio of 3:10, one is doing, as far as I know, quite well. I did say before, so that's one. It's a common industry theme, but it's quite pronounced in the telecommunication industry as well, because we have these huge investments to be made before the next generation of technology can work. I did say before, the second bullet point, that licensing has changed from a 20 to 80 negotiation game to an 80-20 litigation game, which has resulted in what you find on the internet under the label as standard essential patent wars. These patent wars are costly, and what on top is happening in these patent wars is that you start in a patent litigation with a patent, but while the litigation is going on, in the United States, the PTAB, in Europe, the courts, in China, the PRB, are making a second opinion or allow for a second evaluation, validity evaluation of a patent that was granted. All of this is fair enough, but imagine you have invested like millions in a litigation. It's not only the lawyers that cost a lot, it's also the financial experts, the damage experts that cost a lot. You invest millions, and then 2 years down the road, while the litigation is the patent is invalidated by the PTAB and or the PRB or the Munich court. And that's, of course, something on which we would like to have a bit of more knowledge in advance. The other issue, which is quite at stake as well, is which I introduced already in the previous slides, is you have like 100 patent owners who have these 1,000 or 10,000 standard essential patents, and before you license with one, you would like to have some sense of how much the aggregate will cost. How do you come to how do you find out how this aggregate can cost? Well, the minus thing that I can say is that what I see and what people call these top-down methodologies, where they start from declaration databases. Declaration is something that we introduced before. That doesn't work. That is working with something with an uncertain starting basis in which there are 101 variables, and on top of that you had 1,001 hypotheses, and then you end up with the 1 million results that you could, 1 million different results that you could wish to end up with. So everybody calculates to the result they likes or she likes, and so it's what we have in the hands today is not very useful. If I ask to our engineers when we're confronted with patents, and even if a company, the licensor in question, indicates the standard on which they have read the patent, They tell me, "Gun, if you want to find out what could be behind the thought of this company, we need 2 weeks, we need a month just for one patent." And then already they have told us what the patent is and which standard they think about. So that's trying to understand how the landscape looks like is quite impossible. So that's the problems that I see, which I think many people share with me. And there I end my introductory talk.
Great stuff. Well, thank you very much indeed, Kern. Very, very interesting. What I heard there was a sea of thousands of patents and torpedoes floating around in that sea. I heard a lot about money, money, and more money, loads and loads of time, and a hell of a lot of uncertainty. I don't know if Kern ever gets any sleep, but I think if I was in his situation, I would be spending a hell of a lot of money on sleeping pills. So what we're going to look at now is how AI might be able to help with at least some of the issues that Kern has identified, and perhaps identify some other issues that might be solvable as well. So I'm now going to hand over to Julian Nolan and to Harry Cronin from Iprova, who are going to talk about how AI can help in the creation of SEP inventions. And I think Julian is going to get things started.
Exactly. Thank you very much, Geoff. So next slide, please. And before you can file an SEP, of course, you need to create an invention. And ideally, that invention should be a compelling solution to a problem, use case, and need affecting the given standard. And what we believe at Iprova is that the winner of the race to invent, to create the best inventions, will be the best tools. And I think that shouldn't be a surprise to anyone. I think, you know, throughout history, the people with tools have done better than people without tools. And what we're in the business of doing is to provide people with tools for invention creation. And what we've done is to use a variety of different technologies, including AI, to bring a data-driven approach to invention, to speed up invention, and also to make it more diverse in terms of the information that can feed into the invention creation process. We're a company headquartered in Lausanne, Switzerland. We have offices in Cambridge and London in the UK, and then we have sales representatives in the US and Japan. Next slide, please. And if you think about the way inventions normally come about, it's very often the result of an interaction between information and the people that create inventions based upon that information. And if you think about it a bit more, you might realize that that interaction is quite serendipitous and quite haphazard in the way that it very often occurs. So you have information originating all around the world all the time. And what people need to do is to really understand what information from all of the information that's occurring around the world, what information might be relevant to them and what might be relevant, especially for creating inventions in their field. And of course, that's not easy to do. And it's getting more and more difficult because of the volume of information and also the need to invent ever faster. I think with invention, there are no winners if you're second. It's very much a winner takes all game, and you have to be first to invent. And so in a sense, it is a race. And what we're trying to do with our approach is to really distill out the information that's required to create an invention in a given target area and make this interaction between the information that can trigger an invention and the people that create those inventions much more efficient and much more deterministic than it would be otherwise. Next slide, please. So very roughly how it works is that every day we look at a huge number of documents from around the world. And then we use our technology, including what we call invention logic, which is really, I guess, technology that we've developed specifically for invention. We use that then to understand which of the day-to-day changes that are occurring around the world, which of those converge against models that we create that represent the target invention areas. And based upon that, we're able to identify, if you like, the inventive signal in the noise. And it's those inventive signals that we then pass on to human inventors who are then able to create the inventions. And they're able to invent in such a way that because they have the right information at the right time, the human inventor is then able to create the right invention at the right time. And I think that's a very, very key point. We're in the business of amplifying the human ability to invent. We're not in the business of using AI to invent per se. So this is all about really giving humans the tools they need to invent, and certainly not replacing the human in the invention creation process. And so now I'd like to hand over to Harry Cronin, who'll be pleased to explain to you in a bit more detail about how we do that. Over to you, Harry.
Yeah, thanks, Julian. So if we can have the next slide, please. I just want to touch briefly on why having the right information is a good idea if one wants to create inventions in a targeted way. And that really is, as Julian's mentioned, because invention is a product of receiving the right information at the right time in many cases. One of the places in which we can see this to be true is the phenomenon of simultaneous invention, which happens again and again. And there's a sort of, not just us saying this, there's even a nice quote from Thomas Edison sort of bearing this out. But the point here is that if one has access to a diverse stream of new information, which is something that maybe you wouldn't have thought to look for, but is nevertheless relevant to your target domain, then you can invent somewhat faster, and certainly in a more different domain. So yeah, I saw the next slide already. So if we go to that one. A real world example of this, which might be familiar to many people working in wireless, is the example of Hedy Lamarr, who was a Hollywood actress in the 1940s, and also a talented inventor. And one of her inventions, shown in the pattern here, was actually a new system for frequency hopping communications, but was inspired by, and in fact enabled by, the tape mechanism of an electromechanical piano. And the point here is that that piano mechanism clearly came from way outside the core domain of communications as it was understood at the time, or even as it's understood today. And yet, having that information at the right time enabled her to create this invention, which at the time was extremely useful. And even today, frequency hopping, as I'm sure many people are aware, is a key technology component and can be found in standards such as Bluetooth. But yeah, the point to make here is that often the relevant information that you're looking for is from outside of the core domain in which you're working. If we go to the next slide, this brings me on to sort of the first of two key ways in which we think that AI can help specifically with creating inventions which are targeted towards wireless standards. And that is, in a nutshell, by broadening the potential solution space. And this is especially highly relevant today because many standards, if we think about Wi-Fi or 5G, 6G standardization, these are perfect examples, are starting to touch on ever broader use cases. So even already in 5G, people are talking about connected health, about UAVs, about smart cities, direct to satellite communications, and the list goes on. And so it's becoming increasingly hard, or maybe even impossible, for any one engineer to have expertise in all fields. But with that also comes sort of an opportunity, because as the purview of the standardization work broadens, so it becomes increasingly likely that really compelling solutions can be found by using advances from disparate domains to really find the the best, the most sort of optimum way of addressing the use cases and needs within the standard. With the current way of working, essentially expert-led, then there's a risk that these may be missed. So yeah, the first sort of core way in which we believe that AI can help here, as I mentioned, is by broadening the potential solution space. If we go to the next slide. So here we can see just one example from Iprova's invention work in which this has appeared. So the timeline on the slide sort of gives some key steps that relate to a particular invention that was created by a user of Iprova's software. And in this particular case, the information, the inventive signal that was surfaced by the software had to do with a new technique for image analysis that had been published in the research literature. And this new technique for image analysis was picked up on and indexed by our software. And then when the user began their invention creation, which was sort of around themes around 3GPP release 18, if you're familiar with that, so it's part of the work for standardization for 5G. When the user began that, they were able to model that target domain and immediately be provided by the software with this information as something that was potentially relevant for them. And using this information, then the human user was able to resolve a new invention by, part of which was applying this new technique in a completely different domain. So here's something to do with conformance testing, actually. And so you can see here we have this kind of quality of information from outside of the core domain of telecommunications that's being used to drive inventions within it, but in a targeted way. And perhaps maybe this wasn't quite so distant as Hedy Lamarr's mechanical piano, but it's at least got the advantage of being a little bit more immediately applicable to today's technology. And by the way, by operating in this way, and specifically by using automated technologies to retrieve this information, you can also derive quite a significant timing advantage. In principle, this invention could have been created the day after publication of the new technique. If we can go to the next slide, please. Yeah, so as I mentioned, the first sort of core way is by broadening the search space. And I think the second core way that we want to highlight here, in which AI can help with the creation of SEP inventions, is by helping the inventor to work in a more targeted way. So this goes back to something, in fact, which Koen mentioned in his slides about one wants to make sure that the R&D investment that you're making is targeted smartly. This can be difficult to do in standards fields. While in many cases the standardization documents are publicly accessible, they're not always easy to sort of access or utilize. This can take many person hours to fully follow a particular discussion just in one working group, thinking about 3GPP as an example. And this is kind of ironic because actually often the really early stage working documents that are found there may often contain the most inventively relevant information. And here we're really thinking about things like, what is the next high value problem to solve? Where are the discussions trending around a particular topic? Where do we think this standardization process might be in 6 months' time? This kind of information may be present in many cases in the documents, but is very difficult to access. And this is even more true when we think about smaller teams or SMEs, as opposed to sort of large corporate players. And obviously we're sort of seeing SMEs encouraged into standardization processes more and more these days. So the second way that we think that AI can help here is by helping people to target and prioritize their invention work by finding these early stage invention relevant signals from the standardization documents themselves. If we go to the next slide. And so, yeah, this is something that we've been working on recently at Iprova and are launching in the next month. It is a dedicated add-on to our existing software, which is really looking specifically at users who wish to invent in standardization topics. So initially, this is targeted at 3GPP, and in the future, other SDOs could also be added. This does several things. The first one is that it analyzes all of the working documents in addition to the tech reports and tech specs, and clusters them by automatically assigned topics of discussion. So with one click, the user can see all of the relevant working documents to ambient IoT or sensing. The sort of second thing which it does is to predict against each document its likely impact to the future development of the standard. And then thirdly, it provides the user with automatically extracted inventive signals, which are typically problems, although not always. But these are things which are being spoken about in the document, which might be useful to the inventor in their invention work. And this helps them to connect those through from the standardization to the wider world and invent in this kind of cross-domain way that we've been speaking about. And so we believe this to be the first software product aimed specifically at inventors in the standardization space. If we go to the next slide, I think we just have a quick screenshot. In the interest of time, I won't go through too much, but this is really just showing an example in which one of the temporary documents has been analyzed and sort of clustered by a topic, and the user is receiving the extracted problem that's being spoken about. If we go to the following slide. Yeah, so basically in conclusion, sort of to answer the question how AI can help with creating SEP inventions, as Julian said, in order to create an SEP, one must first have a great invention. And in many standardization topics, and especially today, the field of potential solutions is growing. And so there's an increased need for cross-domain invention, which is something that we already know AI is good at supporting from Iprova's several years of work in this field. But to create an SEP, then, of course, it's not enough to just have a great invention. It needs to become a preferred solution to a recognized technical problem within the standardization process. And so now with the new standardization module, what we're attempting to do is to help people to really find those sort of soon to be recognized problems in a strategic and targeted way by looking both inside and outside the standardization documents themselves. But the common theme, which Julian also mentioned, is that we believe the best outcomes occur when the best people use the best tools, and that this will always be a collaboration between the human inventor and the AI-powered machine. Thank you. And over to you, Joff.
Thank you very much indeed, Harry and Julian. A lot to digest there. For me, the big takeaway from all of that is, oh my God, that sounds like a hell of a lot more SEPs. And that is perhaps a segue into the next presentation from Tim.
Thank you so much, Geoff. And thanks everyone for having me in this webinar. I today will talk about two data challenges that we at IPlytics see when it comes to SEP available declaration data, or data that is missing from the world of information. Just quickly, as you know, IPlytics is a company that gathers worldwide patent declaration data, patent pool data, and data from standards contributions. And the first challenge that we always face is something that Kern already introduced in his introductory slides. People refer to over-declaration, even though I do not like this term. I like to say it's a maximal declaration behavior, means that we have databases of declared patents that are not verified to be essential, not by the patent holder who makes the declaration, but also not by any other third party or any standards organization. And that is typically in good faith. We had that also in current slides. Etsy, for example, requests all patent holders to declare patents in a timely manner. That means early on, when the patent is yet pending, the standard is not final, it is probably impossible to declare only essential patents, because the patent, claims are still changing and the standard sections are still changing. However, if we look at the databases today, and let's look at, for example, 4G and 5G, the number of patents that are really essential is very low, right? Most of the patents are non-essential. 60 to 90% of the patents in those databases are likely non-essential patents. However, if you think about portfolios and different companies owning different patent numbers or patent families, you could say, well, if everyone only has, let's say, 20% of their patents essential, we can still count patents. But the problem is, most experts would say the rate at essentiality are different between portfolios because they're different patent declaration behavior. Now, one thing that could solve all this is, of course, claim charting. But again, as Kuhn said, claim charting has to be done rigorously. And that may take from 1 day up to, we learned now, 2 weeks. And if you think about worldwide declared patents, we are approaching over 500,000 declared patents only. If we look at 5G, for example, we have 30,000 active and granted patent families declared. So economically, it's not feasible to claim chart these. So one challenge in that regard would be how AI can leverage AI, or how can AI be leveraged to estimate essentiality of those patents. The second data challenge that we face in the world of patents and standards is that we have some standards organizations that allow so-called blanket declarations. In other words, companies only make statements that they own patents, but they would not list the patents they own, right? So we do not know if that company owns 1 essential patent or 100 or 1,000. So we do not know anything about the magnitude of their portfolio, which makes it impossible to look at patent landscapes for standards, for example, different generations of Wi-Fi, because IEEE has that blanket declaration behavior policy, video codec, audio codec, broadcasting standards, G standard. All of these standards organizations allow only blanket statements of their members, and the actual patent portfolios are not public. One way to solve this is, of course, we've seen that in the industry, people apply keyword searching of certain concepts, which is always inaccurate. We do see, one by one analysis by patents, which is, again, economically not feasible. So one challenge, another one, the second one is, how can we leverage AI to identify those undeclared patent portfolios that are not publicly available right now? The first solution for essentiality that we have created at IPlytics, and I will also introduce this now, but I will also talk about the limitations because that is very important to talk about. But we have leveraged AI to train a model that compares the claims, the independent claims of a patent, to the sections of the standards to identify claim elements in the standard section language. The way we have tested it and trained it is we used pool data, pools that provide information on patent claim standard section, and we also used claim charts. Every patent that is declared gets a percentage of its likelihood of being essential from 1 to 100% in our database. The second solution we created for undeclared patents, situations where we have, a company states to own patents essential to a certain standard, but we do not know which ones. We have leveraged a machine learning algorithm, actually, that comes from our colleagues from Istimo's Cypher, it's called Cypher Certified, to identify undeclared patents for Wi-Fi, AVC, HEVC, VVC, and the G standard. The way the algorithm works is basically we take true positives, again, training data from patent pools, for example, and true negatives. Typically patents from a portfolio of a company, of a patent owner, knowingly owning SEPs, but that are not essential. And with that, the algorithm identifies and basically deletes the noise from the patent landscape to identify patents that are related to a certain standard where, the full picture of the patent landscape is missing. When we talk about these AI algorithms, we always have to talk about the limitations. Let's start with the semantic essentiality scoring, which we call at IPlytics SES. SES only works for English original patent documents. Why? Because the standards documents are also originally English, right? That means it is limited to US patents, European patents, Canadian patents, patents from Great Britain, Australia, and so on. There are machine translated patents or machine translated claims, but the accuracy of that is really not confirmed because the machine translation is not at the level yet that makes sense. Where is SES used right now from IPlytics users? IPlytics users typically use SES when they have a list of patents. Let's say 500 patents. They typically use SES to sort these patents to see the most likely essential patents first. And what we find when we compare that with our training data and our control data, that if you look at the top 20% of sorting your patents, 95% of these patents are typically mappable patents, right? These are patents where claim elements can be found in the sections. Another use case is using SES as a filter. We talked about that we have 90%, let's say, for example, in 5G of the patents that are non-essentials. If you set a certain threshold as an essentiality score, the algorithm is able to delete patents that are really unrelated to the standard, which kind of reduces the noise from your data set. However, and that's already one first big limitation, the algorithm is not yet as accurate to differentiate fully mappable and partially mappable patents. So we can very well rule out patents that are unrelated, but that may only be 30% or 40% of the patents. If you rigorously would claim chart a patent, even patent claims that look close to the standard may end up as being non-essentials. They're partially mappable, but not fully mappable. And that's where the limitations of the algorithm is right now. We cannot identify exactly this is an SEP. We can say it could likely be one, but it could also be a partially mappable one. All we can do right now is we can really chip out and rule out those patents that are unrelated. And that is a limitation that we have to think about when using such data. The limitation also is with undeclared patents. Undeclared patents typically identify, again, patents very much related to the standard, but not, of course, always essential. Another limitation is, of course, undeclared patents identification is very much dependent on training data. If we don't have sufficient training data, we cannot identify all patents for a given standard. The use cases are still undeclared patent landscapes are used to identify the largest patent owners for technologies like Wi-Fi, AVC, HVC, VVC, or the G standard. Those are the standards where we have databases of undeclared patents for. It allows you to look at landscapes. It allows you to identify maybe portfolios that you did not have on the radar. And of course, it allows you, if you are a patent owner yourself, to look at your competition and where they file the patents and monitor that. But again, as to the limitations that we know, these may be standard related, but not all of them standard essential. But even more important and more problematic than having some level of inaccuracy in there is a systematic bias. Because if you want to use such data for licensing, every small percentage counts. And if algorithms are systematically biased, then we have a problem. We, for example, know that if a claim uses a lot of language that we can find in the standard section, even though we use a very intelligent model, systematically, that claim will look more essential than another claim that is written more broadly, with very broadly written concepts that may be much more fundamental, but that uses different words and expressions as written in the section of the standard. Actually, that is very similar to a non-rigorous claim mapping. We do know that in our industry, we have databases, or people have created databases where experts looked at claims just for 30 minutes. There's even a study that was commissioned by the European Commission called the pilot study, I think it's 2 or 3 years ago, that made examiners from the European Patent Office and others claim chart patents for, I think, 6 hours. All of the results show that systematically, if you don't do actual very deep dive essential claim charting, it overestimates the essentiality. In other words, patents that are non-essential identified as essential, so-called false or true false positives. And that typically benefits companies with a lower essentiality rate. And of course, that systematic bias, if you would use such algorithms, or if you use claim charting methods that are not rigorous, they are always biased towards overestimating essentiality, which always helps companies with lower essentiality rates. And those are systematic biases that we have to be very aware of, because if you're not aware of those and use that in your licensing negotiation, it's not a fair system. It's not a an objective data point. And we have a similar concern, of course, with undeclared patents, where if you have a lot of really core technology patents very focused on the standard, you may end up as having a smaller portfolio compared to companies that are filing patents more on the application layers, which may not be so core, but they may have bigger portfolios because we can find a lot more related patents compared to essential patents. So these systematic bias we have to understand when looking at the data. And I think what I really liked from Julian and Harry, they said, AI cannot be used by itself. And I think that's also true for IPlytics. IPlytics is not the truth, right? The truth can only be if a human in our industry makes use of tools like IPlytics or Iprova and bases their minds and their ideas and other sources of information like rigorous claim charts, like expert testimony, combines all that information to get the full picture. And I think that's also where IPlytics is. It's a reference point. It's an information that you get through a tool very conveniently, clean and accurate data from what is publicly available to get you to the next step faster, to give you all the information at hand, to make then a much more educated decision or educated understanding of what's going on. And with that, I hand over to you, Jeff. Thank you.
Great stuff. Thank you very much indeed, Tim. So we've heard now from Iprova and from IPlytics, and there's a lot to digest there. But what I heard from both presentations was that this is, what they're offering, as Tim said, are tools to enhance the work that humans do. This is not about machines replacing humans. It's about machines enhancing the work, or potentially enhancing the work that humans do and enabling them to do it more effectively. Now, Kern, you are someone who would be looking at the kind of products that Tim and Julian and Harry are offering. I just wonder, can you see yourself using what you've heard? What circumstances would you be using these products under, this, or products of this kind? And do you have any concerns about what you've heard?
Questions? Very interesting presentations. And by the way, I could have said it at the start of my presentation, but KPN as a telecommunication operator is both an implementer and a licensor. So we also have our R&D program, we create patents, we have a licensing program, but we also are an implementer. So I always try to look at all sides of the issue. So we work. KPN works with both Iprova and IPlytics. And we have seen from Iprova, coming out from the disclosures of Iprova, nice starting points, as Julian and Harry very correctly summarized, out of which patent applications have born and which have even led to granted patents. We are not the biggest customer of Iprova, I think, so we don't have a huge data set yet. Neither of these patents yet has become a standard essential patent, although they are in the basket of our idea mindset, because our people indeed have worked with the invention disclosures, have incorporated like the ideas, work with it, it improved their work, and so on and so on. So on that side of the, and do we see benefits? Definitely. From many sides. One of the benefits is like a confidential know-how, which I cannot share in the webinar, but there is one. And believe it or not, it has to do with costs. The other benefit is we happened to have a discussion in the team about this last week by accident. If we get these invention disclosures of Iprova, we know that the prior art is incorporated. We know that we are one step ahead of the prior art. So if Iprova does its work well, none of the prior art is forgotten. Talking about IPlytics, that was a very fair summary of Tim. We worked with the data from IPlytics. IPlytics has done some analysis for us. I think Tim has given a very fair summary, like indeed it's a starting point with which we have to work. The challenge for the kind of work of IPlytics is much larger, I think, than making inventions, how strange it may sound. But if I remember, so about, does it sound strange that an invention is easier than finding back inventions? which have been made one day or another. I think so because when I was myself in research, and I've seen these times that we thought we have made a breakthrough, but when you look back at these breakthroughs, it's for ages, like it was perfectly summarized in the slides of Iprova. There's for ages under your hands. You just didn't see it for ages. Yeah, and so yeah, this is my first feedback, Geoff. I don't know if I answered your questions, but
well, no, it's very interesting. I've just noticed we've only got 10 minutes left, though. So rather than ask Julian and Harry and Tim to respond now, what I'll ask you to do, Kern, is go through. Kern's put together a wish list of what he would like to see in the future from AI, and he'll talk us through that. And then I'm going to ask Julian, Harry, and Tim to jump in to respond to what Kern's already said and to respond to what he's about to say. So Kern, I'll hand the screen back to you, and then I just invite Julian, Harry, and Tim to jump in once he's finished. You're on mute at the moment, Kern.
Yeah, I know. I was just waiting for the system to stabilize. So my wish list, I've taken the same bullet points as from my challenges wish list. If in the investments of R&D, we would like to invest in the patent leader. A colleague of us who worked for ages with a leading telecommunication infrastructure company somewhere in the north, more west and east in the north of Europe. Not to mention the company, he said, and we speak about 20 years ago, he said, if I follow 5 of the researchers, of these thousands of researchers there, I have 80% of what I need to have the good patents. So invest in the patent leader. I think Iprova can definitely help us there. Predicting the winning inventions. I heard in the presentation of Iprova that they spoke about indications of independent step. I spoke about this point of having picked up all the prior arts. And then, of course, the next big challenge is find the SEPs in portfolios, which Tim spoke about, and yeah, we all see the challenge. Next step is once you go in litigation, that the patents which you go in the litigation is a safe harbor. That all the prior art combinations have seen before you start in the litigation. So that's my wish list. And then last but not least, yeah, see the full landscape in one glance. Just one click on the computer mouse click, and it's all done. And there I stop, Geoff.
Okay, well, you've got Kern's dreams, Harry, Julian, and Tim. When are Kern's dreams going to come true? Are they going to come true?
So I think. Sorry,
Julian, go ahead.
No, you first.
Yeah, I think as it is challenging. I think it's a step-by-step an iteration process, right? I think we improve every day, every week, and I think we're getting closer to something that is closer to the truth. I would argue that we can at least today identify all licensors. I think that is what we can do. Understanding their actual market share, like do they own 1% or 3% of all 5G patents? That's a much harder question to answer. But do they own likely at least one essential patents, or at least identify a list of licensors, and we are sure that we have everyone in there? Maybe some of them may still not have an essential and valid patent, but at least answer those questions. I think we are there today, but getting to the nitty-gritty specifics of understanding the actual share to the second degree of commas on the percentages is of course a much more difficult question. I think what we're striving to do at IPlytics is work with our clients and support them step by step. What are their needs, when they work with claim charts, with data in combination, and how that can best, help them to save costs and find something they believe in faster. I think that's what we strive to do. Over to you, Julie.
Great, thank you, Tim. Yeah, no, I was going to say that I think, huge strides are of course being made in technology all the time. But I think for many of these things, you know, AI and other technologies can maybe get 90% of the way, but the last 10% is still very much human. And I think that's going to be the case for some time yet, because I think there's a lot of intricacies and a lot of very difficult technical challenges that need to be addressed before we can really see the day when, you know, maybe technology can do all of it. So I think we're getting there, but I agree with Tim, more time is needed.
What I heard from all the presentations and from Kern's comments as well, we're just going to get more and more SEPs, aren't we? I mean, if AI does what you believe it can do, Harry and Julian, a lot more people are going to have the ability to create SEPs. There's going to be more SEPs flooding the marketplace. There's going to be more problems for Kern and people like Kern to deal with. I mean, where does this end? I mean, is this something that we can leave to the market to sort out? Or, you know, we have the EC regulation at the moment being discussed. Are the regulators going to jump in and just say, look, guys, we can't leave this to you. We've got to sort this out because it's just too, you know, there's too much uncertainty, and that uncertainty is never going to end. That's a very deep question with 4 minutes to go, but I'd be very interested to hear people's comments. Maybe start with Kern and then move to Tim, and we'll finish with Harry and Julian.
Let's try in 1 minute because it's one of my favorite topics. What I think that we have seen over the last 5 years is that the judges all over the world start to grasp the problems and the issues, and they make these days very well-founded decisions, which make a lot of common sense when I read them. So when I see that, I say on the one hand, it's a shame on our industry, and I'm really serious about it. It's a shame on our industry that we haven't been able to find solutions. And that's because our industry is so sadly polarized between what one calls the haves and the have-not. So, and it's really a shame that as a well-educated industry group, we are not able to come closer. Setting that aside, we see that there are judges who start to see the left and the right and the plus and balance things. So from that perspective, I am positive that we wouldn't need more regulation. Sad to say that we need a lot of more litigation, but maybe the judges could become an arbitration panel or something. I don't know. I stop here.
Tim?
Yeah, I think I would turn that around a little bit. I think more inventions means more innovation, right? And we should not forget that the 3GPP that develops 5G is the largest open innovation project in the world that combines experts from US, Europe, China, Korea, and Japan, right? Where do we have that? Nowhere, right? So that is something good to start with, and we all use that technology every day. So if Iprova comes along and improves that even more, that's a good thing, right? How we solve SEPs is then the second question. I would also say regulation should only be there where we do have a market failure. And we, as you know, did an economic study on data that is available, and we could not find that any litigation right now is stopping companies from inventing, and it's also not stopping companies from implementing the standards and using the technology. So that's also a good thing. People are improving the technology and they're using the technology. Now, licensing is complex. Even if costly, litigation is part of it. It can be, you know, we have to have enforcement, otherwise the whole patent system doesn't make sense. So I think it's just something we have to accept. And it's not, if you compare the cost, it's not even high cost. You look at our study and the costs are, you know, if you think about how much it costs to file these patents, it's nothing. It's really nothing. So I think that we shouldn't forget. It would be much more costly if a regulation destroys the incentive to invent and destroys the incentive to implement. That would be the most costly thing, I think. So in my point of view, I think we're not in such a bad world right now.
That's very interesting. That's sorry, Julian, just want to emphasize to people listening that Tim was one of the authors of a study that has been cited by the European Commission to justify its regulation. And from what I heard from you, Tim, I think is that you couldn't actually identify any market failure at the moment that needed regulation. So I'd sort of just let that hang. I think that's a very interesting point to emphasize. Sorry, Julian, I apologize. I'll leave the floor to you now.
Just in sort of 30 seconds that we've got left, I think more people using tools to invent more strategically does not necessarily mean that there will be more standards essential patents. What we would hope is that it may lead to higher quality patents. And secondly, if people are using data to invent faster, closer to the point of discovery of a new technical advance, then perhaps it can also lead to more fundamental patents with broader claims and thereby reduce the overall SEP number. And I'll stop there.
Great stuff. Julian, do you have anything to add?
Yeah, I think the world is speeding up. So I think speed is getting more important. And I think people with tools normally do better than people without tools.
Great stuff. Okay, well, with that, I thank everyone for listening in to what I found a very, very enlightening webinar. And I'd like to thank the 4 participants, Kunrad Boytz, Julian Nolan, Harry Cronin, and Tim Coleman for their fantastic contribution. And with that, I'll say goodbye to everyone and see you next time. Cheers. Bye-bye.